1.5. Other relevant provincial and territorial legislation for life insurance agents. In addition to the basic legal framework and contract formation discussed earlier, there are a number of important legal considerations that agents must take note of while dealing with life and health insurance contracts. It is very important that agents remain continually aware of the obligations which apply to them. Poor awareness of such obligations may hurt clients and have severe consequences for an agent, including stiff monetary penalties and even the revocation of the agent's license. Such obligations are described in greater detail in Chapter 4, Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. Privacy Act. In the course of carrying out their business, life insurance agents have access to a great deal of personal information about their clients. How they handle that information is regulated by privacy legislation. The federal government has appointed a privacy commissioner to investigate complaints about breaches of privacy under federal jurisdiction and make his findings public. The commissioner has authority under 2 laws. The first one is the Privacy Act, which is federal legislation governing how the federal government and its agencies handle personal information. The first one is the Privacy Act, which is federal legislation governing how the federal government and its agencies handle personal information. Personal Information Protection and Electronic Documents Act, PIPEDA. More important for insurance agents is the second privacy statute, the Personal Information Protection and Electronic Documents Act, or PIPEDA. PIPEDA sets out ground rules for how businesses and other organizations may collect, use, or disclose personal information in the course of commercial activities. PIPEDA also controls how federally regulated businesses must act in handling employee personal information. If provinces have chosen to pass laws similar to PIPEDA, those laws take precedence in the province. 3 provinces have passed laws for privacy, and 3 others have adopted legislation on the protection of personal health information. PIPEDA ensures that only information that is needed and relevant to conduct a business transaction should be collected. Once the need for the information is over, the information should be disposed of in a careful fashion. The provinces have also appointed privacy commissioners, whose mandate is connected to matters under provincial or municipal jurisdiction. Their mandate is especially directed at maintaining the privacy of healthcare information. Privacy commissioners are also involved with freedom of information activities on behalf of citizens seeking to obtain publicly held or governmental information. In the other Canadian jurisdictions, PIPEDA applies. Human rights legislation. Under provincial and federal human rights legislation, discrimination on the basis of a number of personal and/or group attributes and characteristics is prohibited. On a federal level, such legislation includes the Canadian Human Rights Act, and there is various provincial legislation to the same effect. Discrimination is forbidden on the basis of gender, religion, skin color, national origin, family status, marital status, sexual orientation, and age. Insurers, however, are permitted to discriminate in providing insurance coverage, as long as they can justify it on reasonable and bona fide grounds.